is the Situation Room, the only way to start your day.
Paper, people that you had conversations with, send an email. So there's a digital trail. So when we want to come back into this conversation is walk through the process. I have an idea and maybe I want to make star-shaped chips because it's easier to eat for kids, whatever. And this actually comes out to be a good thing. What should I do? And how do I go about it step by step?
All right. So allow me to do a quick 2-3 minutes of training about the different forms of intellectual property. So I will start with the one that most people know, and it's also the easiest to get and register. That's what I've been talking about, is copyright. Copyright is protected through the Kenya Copyright Board. Copyright exists whether you have an idea of a book, whether you have an idea of a video, music and all that, and you've put it down, right? It's now for the creatives. And it exists at the point of invention, at the point of composition, not the point of registration. So it's the only type of IP that you do not need to register to own. Meaning, if you go to YouTube and say, I can go and claim that this was my music and have your music taken down. That's why you're finding a lot of YouTube disputes. Now, if you're protecting, including those who are doing software apps, can also protect it through copyright. Now, the good thing about copyright now is it's also the cheapest. With the Kenya Copyright Board has opened a portal. It's an online portal. You register and you register your idea, you register your music, you register your catalog, and you can do so for free today. And if you need to expedite it, they've also allowed you to expedite at an additional fee. And I think they removed these fees around COVID just to try and promote more of this. Then we have what most people call patents. Patents could be anything new and novel, but also industrially applicable. Could be medicine like Panadol. It could be a device like a car. It could be your phone has like 200 plus patents. Could be the motherboard, the chip, all these things. Anything that you're inventing that is new, you register it as patent. It's also the most expensive, but it gives you 20-year protection plus. What we call a lesser patent is a utility model. If it didn't fully qualify to being fully a patent, it could be a lesser patent. A good example is our Jiko. Our Jiko was registered as a patent many years ago, but it's long expired. But utility model are 10 years, patents are 20 years. That's why you see medicine like Panadol, almost towards the end, they add Panadol extra because they need to add something extra to give them additional level of protection.
It's not because it works better than the original one?
You also have to maintain that, the exclusivity. Because during this period of time, you have the exclusivity. You will disclose to the world that this is the recipe, but you want to make sure that nobody, despite the fact that you've disclosed, that they cannot use it. So now they have to add that extra before the end of the 20 years. To give you Panadol extra.
That's interesting. We grew up with Omo.
Yep.
Yeah.
Then it moved from Omo to Omo with Powerform.
Yes.
You have
Then Omo with Powerform Plus.
Yeah.
fuel with power.
So all this is because you want to...
You want to extend your patent, but at the same time, there's also something we call brand extension. It's how you can convert something, for instance, you have Sunlight, bar soap and all that. So that's a different form of commercializing. So there's protection, but how then do you make money out of it? You can make many products from it. Then now, anyone who is running a business, and this one I always insist needs to register a trademark. You see that logo you're doing? The name, Situation Room, Spice FM. That name is a trademark or a potential trademark. That logo is a potential trademark if you protect it. Why? Because it will stop other people from using it. I'll give a good example of a startup that successfully did it called Bupas. Bupas set up in 2017, did the bold idea and went and registered a trademark. Then Kenyans do what Kenyans do. Come in, copy, create my own. So Bus comes in and almost sounds similar. The branding is similar. So Bupas, luckily enough, went to court. They got awards. I think as of last year, they got a 10 million shillings award. And you spend about 100K maximum to register a trademark. But after years, you get in, damages and all that. So they got 10 million. They awarded them 10 million.
It cost 100,000 to secure a trademark?
Up to 100,000 because it will also include legal fees, statutory fees and all that. But it gives you protection for 10 years. Every 10 years, you need to renew. That way, you protect that brand. So when you see a Remis, maybe the company behind Aramis is not Aramis. When you see Bidco, you know Bidco oil has changed hands how many times? It's owned by Unilever, then it's owned by another agency, but the brand Bidco remains Bidco, right? Because they've protected that trademark. The brand Coca-Cola remains Coca-Cola. The brand Red Bull remains Red Bull. That's why you see iterations like Dead Bull, and you're able to take them out. So when you see counterfeit, one of the things that you're able to identify, this is not a Samsung because it's a Samsung. That's a trademark infringement. And we need to be able to move to that
Can you
point.
also trademark colors?
We used to. The last, I think, company that was able to trademark colors was Safaricom, the Safaricom green. But I think Kipi has since removed it. But in certain jurisdictions, you could.
Okay.
Yeah.
All right. So then what do you do to ensure that you have, because when we talk about patenting and copyright and things like that, what particular documentation or is there one place where you go and everything is sorted out for you?
Yeah.
Because folks are sitting here saying, okay, I know how you know. I know this thing is going to be big. How do you make sure that it's protected?
Right. So the first thing I always say is, especially if you're moving towards the route of prototype of patents, is create a prototype. Once you create a prototype, you can walk to KIPI offices. That's the Kenya Industrial Property Institute. They also have a website online. You can go to their offices. Occasionally, every so often, they're willing and able to support. Sometimes not to, again, they will tell you we're busy and all that, but they're able to support. But there's only one regulator that regulates at least 80%, 80 to 90% of the IPs. That's the Kenya Industrial Property Institute. And they have the forms. Every type of IP has a form. From the application, if you're doing a patent, you have to do patent description. It's most rigorous. It takes people up to 2 years to get a patent.
Wow.
Yeah. Ordinarily, and it's not a Kenyan, globally.
And you pay for it.
It's expensive.
It's expensive to
But the most expensive thing about patents is getting somebody to draft that patent for you. But then this is what I always say. The first thing you can do is go and file an application. If you file an application where there's an error, they'll come back and tell you, oh, you haven't done this. Right? It can be a rigorous process because unlike many jurisdictions, and it pains me because Kenya, we are a tech society, and so even our regulators should allow for this, but some of it we have to do it manually. In other jurisdictions, you file online. In the US, you're filing the same day and you're getting confirmation whether your application is ready or not. So what you do is you need to file an application. Go and say, this is the kind of patent that I want to create. I'm coming up with a medicine that is from XYZ, because again, medicine can also be, or I'm coming up with a device that will do, sensation, it will test fertilizer or the quality of soil. And then once you go to them and you file this, they will tell you, these are the necessary documentations. If you're not able to always encourage people, now, most of the people who come to me, I send them to that book because we've done a book that illustrates the different steps from filing to the disclosure. It goes through examination. It's, again, as I mentioned, it's very
So for
rigorous.
examination is figuring out whether somebody else is actually something similar.
Yes.
But before you even get there, you've already made payments.
Yes, you make the initial payments of application and the search.
How much are we talking about here?
The cost you're paying to government are not much. You're paying, by that stage, you'll have spent less than 20,000. Yeah. But by the time you are done, especially for a patent, you'll probably have spent minimum of 200,000. Minimum.
Okay, so when you do that, I mean, so looking at when you get through that process and you in that 2 years where you spent that amount of money, what does this then guarantee you once you have the patent?
Exclusivity.
Okay.
Now, you don't have to wait for your 2 years to go to the market. What I always say is, and this is what the dangers of patents are, the moment you disclose and it's in the public, anyone can replicate, right? And so you lose your chances of patenting, right? Because then it becomes open source. But what we always say is, if you have a prototype, the first thing you do is go and file an application. That application will guarantee you that anyone else who comes to file after you, because it's first come, first serve, right? Anyone else who comes to file after you does not get that. And two, when it goes through examination, it will show that you had already filed for that application.
Okay.
During this period, you can operate under patent pending. However, now once you get that, it gives you exclusivity 20 years for a patent. No one else will use that method and all that. If you find that person having done that, then you can go to enforcement. You can take them to court. You can seek damages and all that. So we've seen scenarios where even for big corporates, instead of seeking damages, they've done a joint venture, all acquired. And over and above that, it allows you commercialize in other ways. You can license. I can decide I've made my device or I've made my medicine. I do not want to get into the manufacturing. So I'll sell it to you for 10 million. You go commercialize.
You can continue.
You can continue.
But how does China get away with a lot of this? Because I've seen products or devices even where you can clearly tell the original is this. You go check that the ones who actually came up with it.
Yeah.
But then you see a replica from China, just a small alteration.
Yeah.
How do they manage to get away with it? How can I, for example, take a copy of something that you've done, but I copy, let's say, 80%, but 20% I add something else, and I can claim it's mine?
You need to, each country has its own threshold. You need at minimum more than, you cannot have copied more than 30%.
Not more than 30%.
As in, there's a threshold to, now this is where I separate the words. We have something called invention and then innovation. Invention is completely new. That is where patents exist. Innovation is what else you can do over and above that. So it doesn't mean that because you made a medicine for bacteria, for this type
you're
of
the
bacteria,
only one.
you're the only one who can create. Somebody else can create near it, but not to the extent that is exactly that. So that is also one of the ways in which China does it. The second thing is, if there's something that we do not do as Africans, is reverse engineer. China reverses engineers. You see what I was telling you, Panadol, for the next, after 20 years, it lapses. Somebody else is planning ahead of it. By the 20th year, there's a medicine that is exactly like Panadol. So what happens with patents is, by the time a product is released to the market, remember the filing, I could have filed a patent in 2019 and been in prototype and gotten into business in 2025. A couple of years have lapsed. Now I'm in the market. But during that time, China, an innovator in China is looking at this and thinking, this would really, really work well, but I can modify XYZ. By the time you've gone on to hit the market and your patent has lapsed, they are now ready to launch. So at the lapse of the 20 years, remember it's now fair game. When you go to the chemist and you ask for Moxil, they'll ask you original or generic. The original is the original patent owner. The generic is anyone else who's replicated after the patent expired. So after a patent expires, it is now fair game.
The generic doesn't necessarily mean it doesn't carry the same value.
It actually could be the exact replica. But remember, the patent owner spent so much money. So that is why maybe the products are still costly. But also, no one else will be able to replicate that exact thing for that duration of time, for the 20 years. After the 20 years, it is fair game. I can go and create my own amoxil.
Speaking of copyright, if I take you back and you give an example, for example, the situation room, it can be copyrighted. Can you copyright a name that already exists?
No. You can protect the name in the form that you appear. For instance, Daily Nation, I'll just use this as a good example. Or just, let's say, Situation Room. Situation, that word exists. Room exists. So you'll have to disclaim when you're filing a trademark that you don't own the name Situation, you also don't own the name Room. But the way it's put together, Situation Room, nobody else should use it in that manner, right? With that logo and that's why you put in like the colors and all that. So nobody else will come in and create another Situation Room in this space, in the media space and all that, looking like this. You also protect in a certain class. So that you might find, if you didn't protect nicely, you might find Situation Room as a room for, alcohol and a club and all that. Other situations. Right?
Okay.
Yeah.
Let's look into one that has grabbed the world by storm, and that's in the issue of dupes. And so to find out then, especially in the cosmetic world, so if you create a dupe, what you've done is that, let's say of perfume.
Yeah.
What you've done is that you have taken the scent profile of an original invention, right? You have taken the DNA and you have gone to create something else, and that you've added other scent profiles, but the original DNA you have taken. So maybe you've gone and you've bought the original.
Yeah.
And then your scientists have gone, they've tested, they've been able to extract it.
Yeah.
Then you've gone on to produce it.
Yeah.
Does that go against copyright, patent, such things?
It does go against, I think for perfumes and all that, there's a different type of trademark that exists in other countries. Unfortunately, we don't have scent trademarks in Kenya. But I think that would also fall in within the space of patents. Normally, what I'll also say is what happens, especially within the food and cosmetic spaces, is they tend not to file them as patents or anything. They do trade secrets because the moment you disclose, it's easier to copy. However, any type of a dupe, especially if it's so close, falls under counterfeit. Counterfeit is a criminal offense. We have the anti-counterfeit agency. Unlike the rest where we can talk about, damages that is civil in nature, counterfeiting by nature is criminal. And
counterfeiting doesn't necessarily mean that the product is fake. It just means that you have gone outside of the regulation.
Yes.
Uh-huh.
And you see, this actually one of the industries that suffered a great deal was the battery industry. We had factories that were manufacturing batteries in Kenya for your torches, your remote control, and all that. The counterfeits that came, you will see same colors.
Yeah.
But only one name, it'll change. Like let's think of Gucci. You replace I with Y.
Or you add M, Gumchi. Something like that.
Yeah.
Right?
Or Nike. Remove I. So it is NKE. But it's done in such a way that unless you really pay close attention, hii kitu ni brand niko nayo. It's a counterfeit.
By the way, going back to that, in Kenya, if there's anyone who is so vigilant about counterfeiting, is the East African cables. I have seen them go with cops and the anti-counterfeit agency officers to go and pull them. So if they find you having, even in your own industrial spaces, that you have fake cables claiming to be East African cables, they will take it down.
They will.
They will take it down because, again, it's a criminal offense. You should not, even for you, the assumption is, and you find a lot of people also in the counterfeit in the downtown areas, and sometimes also in the supermarkets, they will walk around and see, this Samsung is not an original Samsung. This Philips, I've also seen Philips also pays a lot of money to do enforcement. Now, that's now where we gone in, you've protected it, now you have to enforce and make sure no one else is doing it. So they pay a lot of money, and they find their officers moving around downtown, moving even in supermarkets. And you find there was a time, I think, a couple of supermarkets were spotlighted for carrying counterfeit goods. And they had to be pulled down from the shelves.
Okay, let's say you are an employee, you work for company X, YZ, and you go to your boss with an idea. And you're telling your boss, I have a perfect way of streamlining our systems, and this is how we can create efficiency. Can an employee sue the boss of the company for taking the idea if there is no agreement on any form of payment? Or can the employee go, patent the idea, copyright something, while still working under the company? Can you do that?
Now, I will go back to what agreement. When you're signing employment agreements, I think it's important that people read the fine lines.
The contract.
The contract. Most employment agreements says that whatever you're creating during the course of your employment belongs to the company. That's what happens in most contracts. And so it would be assumed that you're being paid to come in and innovate, unless it's really, really outside the realms of your space. For instance, if I'm employed as a lawyer and I've decided to invent a device for listening and all that, it's completely different from what my usual day-to-day employment is. So what happens, and this is we've been pushing, especially with Afro Innovation Festival, to get more corporates to own up to the fact that innovation exists. Even we have entrepreneurship. Normally we talk about entrepreneurship, but you also have intrapreneurship, right? If you look at Google, Amazon, they have the 80-20 principle. The 80-20 principle means during your time, if you invent, we can own the idea 80% and we'll give you 20%, which also relates to the royalties. AWS the Amazon Web Service was created that way. Because an employee came, said, I have this idea. I would want us to do it together, but we co-own. I would like to own some shares, then the company owns shares. If that policy does not exist, and this is now we're talking about, we have to start opening up and saying we need policies that allow for innovation within the workspaces. If that policy does not exist, then it does not allow for that, and you as an employee could be, you could be losing your idea. Now, the other thing is also the employer could also be losing good ideas. So most people do it, but they do it behind the scenes, and then they would go on and innovate outside. A case existed between KRA, actually the ITAX. The assumption of ITAX was a dispute with the employee and the employer, because the employer had come with it. Then it was termed different with an invention and said, I think there's a way in which we can be able to collect information and do X, Y, Z. And that was taken up. It's like, I would want compensation, ownership, and all that. And then the employer said that, again, this is in the course of business. So they went to court. Of course, the court did indicate that there was no policy or agreement beforehand. And as such, the invention obviously would then go to the employer. But this is spurring conversations, especially the Gen Z. People are young, they're innovative, they want to work, but they have ideas. So it's either we benefit. We come in and say we're either owning this 50-50 or we're not. I am a product of innovating within my workplace. And I had to go in and sit with my employer and say, listen, there are two ways I can do it behind the scenes, but I would want us to do it together because it's within this space. And we had to agree on a percentage. The employer is happy to foot the bill on what it means to build a brand, and I'm doing the work, and the money will come in. So we are seeing more and more of this. We've been training corporates on how to do the corporate innovation. I need to give spotlight to where it's due. I think I've seen Britam make that effort of opening up the doors for innovation. I've seen DTB Bank do the same. Safaricom has for the longest time done it. And we want to see more and more. I think also Davis and Shatleaf, this is something also I have noticed, and because they invited me in one of their hackathons, that they organized a hackathon or around the problems that they exist. And whoever wants it gets paid and gets a percentage of it. And it's opening up. But at the moment, Dennis, I will say, at the end of the day, you need to go back to your contract and then pull that contract, sit down with your employer and say, I would like to renegotiate. Before you come in and tell the idea, please do, before you give another advertisement idea, go back and say, I would like to renegotiate that I have this, but I would like it clear before I give it to you what these terms of engagement would look like.
Are we getting into a space where folks are more and more aware of these things and how they need to happen?
Yeah.
And I mean, you said that, yes, there are some organizations now that are very keen and aware and making sure that people are protected. But would you say that the profile is rising now in terms of what people know they need to do when it is getting into a startup or, an innovation?
Yeah, I think it's getting better. It's not where we were. We started this effort back in 2019, and my God, it was an uphill battle because we had to teach the very basics. We didn't even have anywhere we can refer them to reading. Luckily enough, we have gotten the support of people who are doing this, but over and above us, there's a lot of conversations. Kenya is leading in Africa when it comes to investments, especially within the startup space. And we're leading despite the fact that we don't have as much money as some of the countries that we work with, right? And the reason, when we see these numbers, they spark conversations within our minds, and this, they make us dreamers, and they make the ones who are losing hope think, actually, this is something. We've also seen a lot of people going out there and doing a lot of capacity building. One of the reasons why we started the Afro Innovation Festival was for two things. Was one, to celebrate. The festival bit was celebrating innovations the African way. And the way we do it is telling people that there's so many problems in Africa, to be honest, which means there's so many opportunities. Where there's a problem, there's a solution. When PayPal back in 2000 was convincing you to get a bank account, an internet, and an email, M-Pesa realized you don't need a bank account, internet, an email, to transact money. Why? Because that was, we didn't have that luxury. And so M-Pesa right now is trading more than paper by far. And so we are getting more and more. We're getting more and more. And the good thing is also we also have a very young, educated youth.
Yeah.
These people are willing and able. We have been able to converge them with Afro Innovation Festival, with Anza Village, with other stakeholders, with universities, to be able to talk to them. It's interesting, actually, when you say this, because I did a segment, we did a hackathon 3 months ago.